Right. Afternoon, everybody. I am Paul Daugherty, and I am the Daugherty in Davis, Upton, Plumbo and Daugherty. And welcome to our ongoing Legal Lunch series. Some of your faces I know from previous Legal Lunches. A lot I don't, and that's good. We're happy to see some new faces. This is our ongoing series. We cover different legal topics that we hope are of interest to people, in particular business people in Southern Maryland. Sort of ground rules wise, the most important thing is that I look at this as a two-way street. Those of you who've come before know that. Yes, we're talking about a particular topic. Hopefully there's a general or a specific interest that you have in that topic. But really, I think we all benefit from everyone giving their input. If you've had a particular situation, without giving away any confidences, by all means, bring it up. Not a lot of formality here. Throw out a particular scenario that you've dealt with. If something we're talking about is of particular importance to you, or you have a particular question, just raise your hand. And again, I think we all learn from one another. Speaking for myself, I always come out of here having learned more than probably I was able to convey in covering the topic itself. Some of you already know the drill. You've got the blue folder in front of you that contains a printout of the slides that we're going to be covering in the overhead here. There should be some area for notes to be jotted down if you want to bring up something at the end of the presentation. There will also be some propaganda in there for the firm, for all the areas that we cover, and perhaps most importantly, there is a questionnaire at the end about what did you like about today's presentation, what did you not like about it, was it useful to you, and what would you like to see in future presentations. And I know it seems like a throwaway. It's not a throwaway. We use those things to guide our planning for the next 6 months in terms of what topics we're going to cover in these legal lunches. So if you can take the only cost for the lunch is filling out that survey, because it really is very helpful to us. Business entities is an area that's very interesting to me personally by way of background. I went to college in Baltimore, and then I went to law school in Philadelphia, but I'm originally from Wilmington, Delaware. And Wilmington, Delaware has a very strong corporate reputation, and by that I mean it is the home for more than half of the Fortune 500s, and there are various reasons for that. It has to do with tax structure, also has to do with the judiciary that's there. There is a separate court of equity in Delaware. And what I mean by that is when you go to court and you sue somebody for money, you do that in a court of law. When you're suing somebody to get them to do something or refrain from doing something, you're going to a court of equity. And in Maryland, those courts have been collapsed. If you want somebody to stop picketing in front of your business, you go to the circuit court and you ask for an injunction. In Delaware, if you want somebody to stop picketing in front of your business, you go to the court of chancery. They can't grant money judgments, but they can tell people what to do or what not to do. And a large part of Delaware's reputation as a good state to incorporate in comes out of the decisions handed down by the Court of Chancery, mostly in the 80s and 90s, having to do with corporate governance. Most of the decisions that say what a board of directors has to do, what a president or vice president or other officer of a corporation has to do, come out of the Delaware Court of Chancery. The biggest decision, and this is taught in law schools across the country, not just in Delaware, there's a decision known as the Revlon decision, came out of the Delaware Court of Chancery, was affirmed by the Delaware Supreme Court, that said, in the era of all these hostile takeovers and other things going on, what is the duty of the board of directors once the company is on the block? What kind of offers do you have to consider? What can you reject? What are your duties? And we're not going to get into activist shareholder litigation and those types of things. Those are not really within the scope of this. of today's presentation here, but I bring it up because how businesses are formed, the structure that they take when you form them, are all very important, and they touch companies the size of Revlon all the way down to little old firms like Davis Upton here, and some of the businesses that you all are either members of or deal with, I presume, on a day-to-day basis. So to know how those companies came to have the structure that they did, what it means for you in dealing with them, is pretty important. During the presidential campaign last year, Mitt Romney got in a little bit of trouble because some people were unhappy when he said, corporations are people, my friend, at a campaign stop somewhere. And he caught a lot of heat for that because I think people perceived him as being out of touch. I don't know what really. But from a legal point of view, corporations are indeed people. In the law, there are two types of persons. One is what we call a natural person, which is you and me, an actual flesh and blood person walking around. It can also be a corporate person. And a corporation, in the eyes of the law, is its own person, has its own life. A limited liability company, a different type of entity, business entity, also is, in the eyes of the law, a legal person. For instance, if a company wants to, strike that, if you want to pursue a lawsuit in a Maryland court, if you're an individual flesh and blood natural person, you can do that without a lawyer. You can do it pro se. A corporation or a limited liability company or a partnership as a corporate person can't do that because there is no flesh and blood that can actually show up in court. It has to have a representative, and therefore, even on a small claim for $2,500 in the district court, you have to have a lawyer to represent that corporate person. Company can't appear pro se. The reason I bring that up is because we're going to be talking about the differences between corporations, limited liability companies, limited liability partnerships, limited liability, limited partnerships, all these crazy animals that are out there, as if they are a separate entity from the people who run them, because legally they are. That's really the heart of the matter. Let's see where our slides take us to start off.
Is it on?
I'll have to find out.
It should vibrate.
It's vibrating. There we go. Start off with a little joke. Distinct legal entities. Creatures of statute, in addition to being their own legal persons, corporations, limited liability companies, limited liability partnerships are creatures of statute. What that means is they weren't just thought up. In most jurisdictions, and certainly in Maryland, the legislators have enacted statutes which govern what does a corporation do, what does it have to say in the papers that create it, what does a limited liability company have to do, what can it say or not say in the papers that create it, who can have an ownership interest in it, who can have a management interest in it. Are you limited in the number of people, and when I say people I mean both natural people and corporate people, who can have an interest in a particular business entity. That's all spelled out in the Business Association's article of the Maryland Code. I wouldn't recommend reading it unless you're an insomniac because it'll put you to sleep, and it has really insane provisions in it, like when you want to know what a closed corporation is. There's a definitions section. So you go in, you hit the definitions section, and it says a closed corporation is any corporation designated pursuant to the terms of this article as a closed corporation. The people who wrote that and printed that should be ashamed of themselves for wasting all of our time. But as I say, they're distinct legal entities. They're created by statute and carry on business in their own name. Companies, corporations and limited liability companies, and that's mostly what we're going to focus on here, They're fictions. They're legal fictions. They can do things on their own, separate from their management and separate from their ownership, which sometimes are one and the same, but not always one and the same. But when a contract says that ABC Corp is going to lay the blacktop, the president's not going to do it, although he may be the one out there doing it. It's a small company. It's the company that took on the rights and obligations of that contract, and that's who you're doing business with, the company itself, not necessarily its officers, not necessarily its employees or its owners. And again, you get in trouble on a contract with a company, the company is going to be the party that's either who you sue or who's going to come after you and sue you. Continuous existence. And these are all just hallmarks of these corporate entities. We'll get into the specifics later. Continuous existence. You can have presidents of the company come and go. You can have certainly shareholders of a company come and go. And that doesn't change the existence, the legal existence of the corporate person, the company itself. It outlives its presidents. It outlives its shareholders, unless it gets dissolved, in which case it's essentially dead. Common types. Talk about corporations first. A C Corp is what we typically think of when we think of a corporation, without too many limitations. A closed corporation, that's sort of an odd name. I always say the way to think of it is to tack on an LY at the end of the word closed. It's a closely held corporation. An S corporation. An S corporation is notably, or most notably, distinguished because it has a flow-through tax status, unlike a regular corporation. We'll get into tax status later. Religious corporations, and all these are, again, provided for in the Business Association's article of the Maryland Code. Religious corporations are set up specifically for the organization, management of a church or synagogue or temple. Nonprofit, non-stock corporations, Maryland has specific rules for if you run a not-for-profit organization or a charitable organization. Professional corporations, these are lawyers' offices, doctors' offices, architects, those types of people. Anybody knows Tom Axley here in town? He's been practicing law for 1,000 years. His company is Thomas A. Axley, I think he calls it Chartered Professional Corporation, something like that. A professional corporation is, by Maryland Code, set up for that particular type of industry. And the only true, or the only distinction we really care about is that a majority of ownership in a professional corporation has to be held by someone who is licensed in that profession. So you could have a professional corporation to practice law that has 10 people in it. At least 6 of them have to be barred to practice law in the state of Maryland. Doesn't mean you can't have other ownership, but a majority of them have to be a lawyer, a dentist, something else. Yes?
Is it correct that the closed corporations are actually, an S Corp can be a closed corporation or not a closed corporation? It actually comes under that?
It can be, and some of what to keep in your mind as we go through today is these distinctions, as we spell them out, are not necessarily exclusive. That's right. But you can't have a C Corp that would be a closed corporation, because one of the limitations on a closed corporation is, on an S Corp is you can only have 75 shareholders, and most corporate regular C Corps are much bigger than that. And we'll talk about some of the other limitations, like on closed corps, you can do away with the board of directors.
Right.
You're then shifting management into the shareholders' hands, which most people don't want, but we'll talk about all of that.
And I have one more quick question.
Yeah, sure.
Is that a Maryland regulation? Is it also recognized in different states? Does the federal government actually have a condition for it?
Typically not. It's a jurisdictional thing. There is a uniform limited liability company act. And by uniform act, it means that a bunch of academic people got together and drafted what your state statute ought to have in it in terms of how we govern these things. Same for corporations, same for partnerships. Like the UCC, you may have heard of the UCC, Uniform Commercial Code. How should we deal with one another commercially? It's not federal, it's really just an academic broad guideline set of draft statutes that Certainly Maryland has adopted, Delaware has adopted, each jurisdiction adopts its own version, and will typically tweak it for what goes on there.
Does Delaware have closed corporations as a provision?
I believe so. I believe all of these are in both Maryland and Delaware.
I have a quick question.
Yes.
On the religious corporations versus nonprofit, if you had a ministry that was religious-based, or let's just say the ministry, they run a soup kitchen or something like that for a specific need. If you're a nonprofit, you have to deal with the 990 and all that crap. Is a ministry like that, could that go under religious corporations, or is that just for churches?
It could go under a religious corporation, but the way you phrase the question starts to sound more like an accounting question than a legal one. And this is an area where tax accounting and the law intersect, but it's hard to give an answer. I don't mean to sort of pass the buck, but I don't want to say yes or no based on what sounds more like a tax question than a legal question.
Oh, okay. Yeah.
Generally speaking, whether you're going to fall under nonprofit, non-stock, religious, or professional, you're really talking more about the focus of the organization itself, its operational focus, as opposed to how it's...
And then the accountant, so to speak, or tax person would know more which corporation entity they're under.
They may have an opinion on what form would suit you better, whereas lawyers are typically going to tell you, day to day, what are you going to be doing, and what type of protections do you need if that's what you're going to be doing. And so for this type of work, we really do often, almost always work hand in hand with whoever the accountant is to say, here's what the client is saying, after we get the client's permission to speak with them, of course. Here's what the client is telling us they want to accomplish with this business organization. Here are what our sort of gut recommendations would be. Are there specific revenue issues, tax issues that you, accountant, know about that might change that opinion, and together let's give good advice. Partnerships, general partnerships and limited partnerships. We're not going to spend too much time talking about these because these are, to my mind, not really usable anymore these days. A general partnership, you might as well be a couple of sole proprietors who got together to do business together. Almost zero protections there, so why would you do it? A limited partnership, you got to have at least one general partner and one limited partner, and the partners can limit their capital contributions to the partnership. They can also limit their liability, but a limited partnership requires a general partner who will be on the hook for all of the partnership liabilities. I'm probably sounding very negative about partnerships because I am, and we don't spend a whole lot of time discussing them because I just don't think they're a very suitable modern corporate form. Limited liability companies. Davis Upton Palumbo Daugherty is a limited liability company. We'll talk about some of the flexibility you have in that corporate form, some of the protections you have. We'll touch on some tax issues. But for now, there can be multiple members. Here we have multiple members in the LLC. I am one. You can have an LLC that has a single member. There is absolutely nothing wrong with that in Maryland and in most jurisdictions. So we sort of sketched out what these things, or that these things exist. So what are you really focusing on if you are thinking about starting a company? And let's take a moment. Why would you do business as a company in some corporate form? Why would you get to this point of making that decision as opposed to just going out and going into business for yourself as a sole proprietor? Anybody mind if I take the jacket off?
No.
Yeah,
you all do.
You make me stand here and sweat? Why would you do that? Well, you may do business as Joe Smith and do a good job at it, and everybody knows that's your business. It's not your personal life. You've got office space. You don't work out of your house. You've got trucks. You've got employees, and you've got insurance, and you've got all that jazz. Well, guess what? When you get sued because one of your employees ran somebody over with one of the trucks, there ain't no company that's going to get sued. It's going to be you. And you get a judgment against you for $100,000. they're not going to care about the trucks. They're going to come after your house and your golf clubs and your bank account and everything else. So doing business on your own as an individual, I don't care how formal your business is, how beautiful and corporate looking your office is. If you're doing business as a sole proprietor, you literally stick your neck out. Because if you ever get sued, they're going to take it from you. Again, generally I look at partnerships the same way because there's not much protection there. So you made a decision, I don't want to be naked to the world legally and financially, and I don't want to operate as a sole proprietor. Now I'm at the point of deciding what corporate form do I want. What am I considering? Limitation of liability and tax implications. And we'll talk about limitation of liability first. It's the flip side of the coin I just described. I don't want my neck out there. I'll put the company neck out there, but I want to protect myself, either as an owner of the business, we'll call a stakeholder for now, or as an officer of the company. And again, in certain types of corporate forms, the ownership interest and the management interest are together. We say officers, talk about president, vice president, secretary, and all that stuff. You want to be able to run the business or own the business and be shielded from the liability that the business might have. And when we talk about liability, we're not only talking about the guy who sues the company because one of your drivers ran him over with one of the company trucks, but you're also talking about financial liability in terms of obligations under contracts, meaning nothing went wrong. There's a cash call. Is that cash going to come from the officers? Typically not from the officers. Going to come from members? Is going to come from shareholders, stakeholders? So all that kind of protection. Tax implications. Here, while tax considerations are usually complex enough that we want to work with an accountant to have specific advice, what we're really talking about here is fairly simple, meaning as a general provision, do you want to have a dual layer of tax liability or a single layer? What I mean by that is a corporation gets taxed on its income. What's left over after that tax liability pays all sorts of stuff and distributes a salary out to officers, distributes perhaps a dividend out to shareholders. You then get taxed on what you receive then. So there's two layers of tax liability there. A limited liability company, for instance, Davis Upton, the easiest example for me to think of, the revenue that comes in, the LLC doesn't pay any tax on that. The tax liability gets passed through 100% to the members. So, and without sort of sharing too much dirty laundry, every month, we hope, I get a cut, right? I get a distribution from the revenue of the firm. When that comes to me, there's no Social Security taken out. There's none of that. It is a chunk of money that then I have to pay my own obligations out of. So the company hasn't taken care of any of my stuff, nor has it, the LLC, paid any tax obligations of it, so it's purely a flow-through entity. Whereas a corporation, slice comes off the top for the company paying its taxes, then any stakeholders receiving revenue from the company, they're then going to get hit again. And there are adjustments that are made, but that's typically the distinction. Limitation of liability. Yes.
Sorry. Let's say if you're a liability, an LLC, can one type of corporation be under another type of corporation?
We covered
Protection.
That's right. You can have, and when this happens, I typically get out a legal pad and I actually draw a map. You can have an LLC where the members of the LLC are other LLCs and other types of business entities. And sometimes it gets very confusing, usually because it'll be ABC Corp, ABC LLC, the members of which are ABC1 LLC, ABC2 LLC, XYZ LLC, Brothers Fund Company LLC, and you got to sort all this stuff out. There are some types of organizations that limit what you can have as a member But typically, yeah, you can structure it so that it's not just natural persons who are members of a limited liability company.
Can I ask you a quick question?
Yeah.
When you're talking about the LLC and the revenue flow through, and not to get too specific, but so.
It was beyond what I know. I won't answer it.
So at the end of the month, you say, you get, as a member of the LLC, you're getting a cut of the revenue. Are you then getting a 1099 for that cut of revenue at the end of the year? Because you're not paying taxes or not paying.
The best I can do is tell you what I do, and I do what my accountant tells me to do.
Okay.
And that's those damn accountants. What I do is I pay quarterly estimated.
Okay, so you do that quarterly estimate, but yeah, nothing's coming, and then basically at the end of the year, you're getting
And
a form that says we gave you this much money.
right, you get a K1. That's exactly
okay.
right. And that's a good question. But for purposes of what we're talking about here, the focus for that tax liability is more what happens at the organizational level. A corporate organization, Inc., is going to pay taxes before anything happens to the stakeholders. Any distribution goes to stakeholders. An LLC, it is purely a pass-through. The company's never going to pay any tax on its revenues.
But that K-1 does kind of serve as a 1099, except it just.
Yeah, the information,
Yeah.
the information, and we do a lot of, I give my accountant an estimated K1 at part of the year just to see what things are going to look like, so he can tell me, look, stick a little more away, make a higher quarterly, that type of
Right.
thing.
And it also passes through, but you've got to consider passive versus non-passive income and losses, right?
All that stuff, that's right.
Yeah.
Which is why I pay my accountant, to not have to think about this. So I can actually, hopefully, focus on practicing law. Yeah.
Sorry.
I'm going to get a bottle of water.
Sure. Keep talking. If, say, the funds are kept within the LLC, not distributed to the members, like in a bank account, how are taxes paid on those funds at the end of the year? If it's not...
That is a purely accounting question, but I'll take a guess at it. They're not, because that money is being held in trust, arguably, for the members of the LLC. That's really the only way I can answer that one.
I belong to an investment club, and we're LLC.
Okay.
And we get a K-1 at the end of the year and have to pay our own taxes on it. We don't get any money during the year.
Yeah, so I think it is based on income, not cash distribution. So if the LLC is showing a profit and loss, at the end of the year, you're going to pay taxes on your portion of that profit and loss, regardless about what they distribute from a cash flow
Whether we get anything or
perspective.
not.
Yeah.
So if you have several members and some members are pulling salary and some may not be, that would all have to be tracked as maybe an expense and distributed.
Yeah.
Roughly, yes, because a salary that gets paid is an expense of the LLC as opposed to, and it would arguably come out before distributions were made to the members.
What you get isn't considered salary, that's just the distribution, right?
That's right. Although my accountant says, he talks about, should we, label this an actual structured salary? And I say, well, the term of art, but no, it's a distribution. The company pays out everything it needs to pay, rent to the building, toner, salaries to the staff, and whatever is left over is what the members of the LLC get. My accountant doesn't look at, what I get in a particular quarter. He doesn't look and say, well, how much was paid for toner this year before you got that distribution. He's only looking at what came to me. Limitation of liability, and again, this is really the reason you want to create a corporate entity to begin with. You want to have protection, and it's based on this. There's usually there we go. Doctrine of respondeat superior, little Latin, because you don't get your money's worth unless you get some Latin when you come into a law firm. The principal is liable for the acts committed by its agent. Typical agent relationship is one of employer-employee. If the employee commits a tortious act, not tortuous, tortious act in the performance of his duties, a victim can not only sue the employee but can also sue the employer under that doctrine. So essentially, if I'm a individual, I hire a guy, he runs over you with my truck, that's as long as he was driving the truck within the scope of his duties as an employee, it's as good as if I were driving the truck and ran you over. So, now, just an interesting aside, an agency is its own area of law. If he had to deliver parts in the truck from my shop to one of our clients, and he took a detour to go to the liquor store, and he hit you in the crosswalk on the way to the liquor store, then I might not be liable for that. And young David Weigel over here, one of our associates, is piping up because he probably has a hilarious story.
We actually had almost that exact case. Where the victim, actually the victim's insurance company, had come after both the driver and the employer looking to get their money back. And we had the employer, and he said, hey, you were off that day. And the employee said, well, I was driving other employees to work at your request. And the employer said, A, that's not true, and B, you actually had gone to the liquor store and were driving home when the accident occurred. So Paul's example is not that far off. So sorry to
And people often, no, it's great, thanks, Dave. People often wonder, why do lawsuits take so long, and why does all these legal fees incurred? And my dad used to ask that all the time. And I say, because you think, I got hit. I should be able to be compensated for that. Well, you got to wind your way through all those facts of, were you stopping to get gas? Were you going to the liquor store? Were you acting at the direction of your superior to go do something like this? And all that stuff is done in depositions, and where there are lawyers arguing about what you can say and not say. So it's not hard to see when you hear something like that under the umbrella of, were you acting as an agent of the company or not? It's not hard to understand why these things can spin out into litigation that takes years and years and hundreds of thousands of dollars in legal fees. Thank God. What do we have here? Limitation. Why? I'm not gonna fudge it. I'm not gonna pretend I'm not here to make money. So anyway, with that as the sort of the template, what do corporate forms do for you in terms of the limitation on that liability? Generally, the owners of a company are not personally liable for the acts of their employees. If you're a sole proprietor, you are the owner of the company, and you will be liable. If you are an owner of a corporation, you will not, because owners of corporations are shareholders. So when the Ford plant in Dearborn has some machine break down and fall on a guy and kill him, you don't sue 500,000 shareholders of Ford. They only own the company. They are not the company itself. You sue Ford. That is a layer of protection that's almost untouchable or unbreachable in the law. We'll talk about ways in which it can be breached, but typically, look, I'm not going to buy stocks at GE or Ford or anything else if I think that every little injury that happens, by injury I don't just mean pianos falling on people, I mean the secretary of the company takes off with the pension fund and goes to Tahiti. All the pension beneficiaries are then going to sue the company. That's liability too. I would never buy a stock, and nobody would ever buy a stock and become a shareholder and become an owner of the company if you thought you'd be on the hook for that. So that's part of the protection. And what flows from that is, as a shareholder of Ford, I actually do own Ford, as a shareholder of Ford, nobody's ever going to foreclose on my house because a piano fell on somebody in Dearborn and then they sue me. My assets are protected. And that is really the main reason of sort of what we've been talking about all along. That's the main reason of going into business as some type of corporation or some type of limited liability company, as opposed to sticking your own neck out there personally. Partnerships are junk. Don't worry about them. And this is why. This is why. Partnerships, in a general partnership, each partner is liable for the acts of all general partners and the employees. It's, in my mind, it's the same thing as sole proprietorship. Why would you do it? Except that now, instead of worrying about what I do wrong, I got to worry about what all the rest of these guys do wrong. And I'm on the hook for it all. We don't. Besides pianos being dropped on people, we don't pay an employee enough, right? Something gets wrong and they don't get paid enough. They're going to come back and sue for whatever they think they're owed. They're not only going to sue if Dave screws up and we're partners. They're not just going to sue Dave. They're they're going to sue the partnership, which means I'm now responsible for Dave's mess-ups and vice versa. So it's really an exponential liability issue.
Just real quickly, in law school, my business association professor said flat out, if you allow someone to create a general partnership, you are committing malpractice.
Yeah, that's
It's that
limited partnerships sort of take the edge off a little bit if you are a limited partner. You can come into a partnership and say, and again, limited partnerships have to have at least one general partner, at least one limited partner. That one general partner is the target for any liability. The limited partner will be protected from that liability, but generally the limited partner is also going to get a commensurate reduction in the cut of revenues out of the partnership. I don't know why you do either of these things. I really don't.
Can you structure a member within an LLC that kind of acts like a limited partner? Maybe through the operating agreements. Like they're not active in the management or even an officer, but they are a partner.
I can't point you to a statutory provision, but I believe you can, because that liability flows down, or can, depending on how you protect. It doesn't flow up necessarily. Meaning that limited partnership, if there's a partnership that's a member of an LLC, the LLC itself is not going to take the shots that that partnership will, generally speaking. Corporations. This is your strongest form of corporate entity. It's free transferability of interest. I can sell anybody here my shares in Ford. Ford really doesn't have anything to say in it. They just put the shares out to market, and whoever owns them owns them. Perpetual existence. Again, you can have generation after generation of officers. You can have generation after generation of shareholders. Come and go, company still lives. One characteristic, centralized management. You've got officers, you have a board, and then the limited liability we've been talking about. Ownership and management should be here. Corporations are owned by the stockholders. That's what we've been talking about. Stockholders elect the board of directors. I spent the majority of my corporations class in law school going through all the minutiae of staggered boards and how you elect staggered boards so you can never get too much control of the board by any one group of board members, how you have proxy fights and all this other jazz. And that, again, stems out of a lot of the activist shareholder litigation that was in Delaware in the 80s and 90s. I graduated from law school in 98, so that was still sort of fresh in people's minds, where you had people coming in. And in those days, I think it was less sort of pension group focused ownership, but it was, in some cases, big guys like Kirk Kerkorian, but also little grandmas coming in and saying, I don't think the board operated in the right way and didn't follow its obligations, and come in, and all that stuff gets litigated. But as you all probably know, the shareholders and the board of directors and the officers in a corporation all have different obligations. Closed corporations, the exception. All right, I wrote it down, but I didn't put it in there. In a closed corporation, a closely held corporation, you can elect not to have a board of directors. Sounds great, right? You don't have to put all these decisions, the officers don't have to put all the decisions to a review by the board of directors. Sounds good, but isn't necessarily good, because then the shareholders themselves have to assume a lot of those management responsibilities. And one of the protections, at least in the Maryland statute, is that for most corporate decision-making in a closed corporation, you have to have unanimity of shareholders to make that decision. And if you don't, you can have an involuntary dissolution of the company by any one shareholder who was snubbed out of a decision. That's a big poison pill that closed corporations, again, I think it's limited to 75 shareholders. That may be S corps, so I have to check my notes, but typically for closed corporations, you are looking at what would otherwise be a mom and pop or a family business. They want the protections of limited liability, but the decision makings are probably going to be unanimous anyway, because dad is Tony Soprano and says, here's how it goes. If you don't like it, you're out of the company. you're not going to run GM as a closed corporation. And we'll talk about some of the roles here for people. Board of directors, they set policy, they appoint the officers, or they, if you've got a succession plan, they will sort of bless the choices for officers of the corporation. The officers are responsible for day-to-day operations. These are the people who are the face of the company, typically. So how do you build one of these things? There are a set of documents that you have to prepare, the articles of incorporation. And that's a fairly standard document. It basically says, we are hereby forming this company. It may or may not contain reference to the other documents. Typically you will. It may or may not contain, either in it or as an addendum, how many shares are going to be issued, what their par value is, meaning the dollar value we're going to assign them when they go to market, when we create this company. They may all be spelled out in the Articles of Incorporation, but the articles are what you file with SDAT. That's a birth certificate for a corporation. Okay. The bylaws are internally, how's this company going to operate? How's it going to make its decisions? How do you build a quorum amongst shareholders? How do you, what kind of decisions are made by a simple majority? What kind of decisions are made by, are going to be left to the officers themselves? We're going to go ahead and concede these decisions to the officers. That's the bylaws. That's sort of the guts of the day-to-day work of the company. Organizational meeting. One of the quirks of forming an actual corporation is that you have to have an organizational meeting when the company's formed. It can be listed as an informal meeting, but it has to happen. In some of the other forms, you don't need that. You can also terminate a corporation's existence. And I advise that if you have a company that's winding down and you're going to close it down, don't just leave it hanging out there as a company which has not maintained its good standing status with SDAT. Go ahead and shut the thing down, dissolve it. You got to have a period at the end of the sentence. When that happens, the assets of the company, if you haven't sold them off, if you haven't to pay debt, or you haven't sold them off because that was what you got into business for, they are vested in the directors, have the responsibility of paying off all debts, distributing the remaining assets to stockholders. So what that means is you've got some control in the board after the company ceases to be. Their duty is essentially a wind down duty. A lot of the work that I did in Delaware was in corporate bankruptcy work. And so after the company, as the company was winding itself down, you're looking to the board to get their authority to preserve assets, sell them for the best return to creditors. You know, in Maryland, there's actually also some case law. Dave, you may remember it. I don't specifically, but where you've got a company that loses its good standing status with SDAT, can you still sue them? The bigger question is usually, is it worth doing? Because the company is not in good standing and not running. There's probably not much reason to sue them. But there are some corporate activities which will survive the company winding down, and you can go after the board of directors, not personally, but for whatever assets they are still charged with having the duty to dispose of. So it may be worth doing. Usually you're going to find out there just ain't nothing left, and it's not worth doing. Okay, so we've established this big protection that a corporate form provides. It's its own person. It's a shield against the ownership. Typically also a shield against management in the officers and the board of directors. Can you ever bust through that shield to get to officers, board members, or owners? And yes, you can. And we call piercing the corporate veil. Typically, when you're doing this, you're not talking as much about giant corporations. You're talking about smaller ones, because the big ones usually set it up right, and they know what these dangers are, and the protection is fairly complete. by the way in which you pierce the corporate veil, you'll understand what I mean. Fraud. The guys who set up the company don't follow any of the statutory formalities. They don't use the name corporation or Inc. in the name of the company. They don't hold that initial organizational meeting. They don't file articles of incorporation. They just hold themselves out as a company. Well, you're not a real company at that point if you don't follow those formalities. It really is a checklist of things you have to do. Or let's say you do follow all those things, but the company is clearly a shell. Well, in large part, the company is made, the whole reason you do a corporation is that it is a shell. It's there to protect you. If you dig a little deeper and you show that the company had no revenue of its own, the only revenue it had was the revenue that its officer was generating for himself and then hiding it in the corporate form, in the corporate books. It didn't have any reason for being other than for its president to put all his money in. Then you can say, you can pierce the corporate veil and you can say this thing not only was a shell, it was really a sham. And it never had the hallmark of an actual separate legal person. It was just a hiding place. And then, of course, you got good squishy language like to enforce paramount equity. We don't know what that means. It's like the Supreme Court used to say about pornography. You know it when you see it. When you see, again, abuse of that corporate form for something other than what it was meant to do. When you see something like, it's more equitable to pierce the veil than to provide the limited liability to shareholders, that's a different way of saying it's a case-by-case basis. I will say this, though. Maryland has a very high standard for piercing that corporate veil, along with Delaware, which is perhaps the strongest in the country. Maryland says the default position is that this company is good until proven otherwise. We're going to assume that it's good. You can show us that it's not, but they really honor the corporate form until you can prove otherwise, which I think that's how it ought to be. LLCs. Here's sort of a very stiff definition. Unincorporated business organization similar to a general limited partnership, but possessing a shield which protects its owner from liability to the same extent the stockholders of the corporation are insulated from the corporation's debts and obligations. We talked about the characteristics of a corporation. We talk about the characteristics of a limited liability company. Limited liability company, trying to limit the liability of the actual owners. Centralized management or not. It can be managed by the members or have one or more general managers. And typically, in the documents you use to create the limited liability company, everybody who has an ownership interest will be called a member. You may have one or more managing members because, and again, I have to default to how we operate here. Certain decisions that this law firm makes, this LLC makes, I get to participate in because I'm a member. But frankly, I don't want to have to negotiate with the toner guy and the copier guy and the guy who delivers the bottled water and all that jazz. So the managing member, we as non-managing members will have ceded some level of control, operational control, to the managing member or members to make those decisions. Not because we're lazy, but because it's just unwieldy to have to take a vote from all your members about, do we go with Canon or do we go with Xerox? We don't do that, but you could do it. You could make every member a managing member, and you could have to make a vote for all those minor decisions. It's really flexible that way. Perpetual existence or specified life, whereas a corporation exists, you can spell out for a limited liability company that with the death or departure of the last member, the LLC will cease to be. I tend to think of them more like corporations where you have members coming and going. So that it does have a life of its own beyond the membership, but you can structure it that way.
Like in a sole proprietor. So that when that person dies, the LLC is dead.
You can structure it that way, yes. That if the last member dies and you haven't made any new members, that yes, it will terminate.
Okay.
No free transferability of interest. Members must approve assignee. What it means is I can't tell I call them partners. We're not a partnership, but I call them my partners. I can't go out and sell my partnership to my brother, or I can't go out and sell my partnership to Dave and say, I own this asset, which is a certain percentage of this company, of this LLC, and Dave makes me the right offer, I can give it to him. The other members of this LLC, my partners, can ixnay that and it'll never happen, and vice versa. LLCs are owned by the members. There's no shareholders. The members are essentially the shareholders. Membership rights versus membership interest. The rights are I get to vote on the big decisions we make, most of which are management decisions. My membership interest is that I get a cut of the revenues that are left over at the end of each month. It's a distinction. It's a bit academic because they're really merged together in the organizational documents. But you could have people, you could certainly set it up in your documents for an LLC that I'm going to get my cut, but I do not participate in the management of the company, of the LLC at any level. Or I participate in the management, but I don't get a cut. Why you would do that, I don't know.
Jump in. Another thing sometimes you'll see in the provisions that spell this stuff out is that, especially if it's like a family LLC, where if Paul wants to sell his membership interest to an outside party, that's fine, we can approve that. But once it goes to somebody outside the family, there's no membership rights with that interest. Yeah, so that is one way where they can be separated.
It's interesting to distinguish between this and shareholders in a corporation where the ownership interests are free-flowing. There is, and has been for hundreds of years, literally a market to trade ownership of the company. You can't do that with an LLC. Maybe an interest holder, but not a member. Formation, and here we're going to go back to sort of like we did with the articles of incorporation and the bylaws for a corporation. For an LLC, you have articles of organization, same function. You got to call it an LLC or limited liability company. You have to state what the purpose of your company is. The purpose is generally going to be very broad, to invest in real estate and all the pertinent interests there too, and that means you can do anything really. You got to give a physical address. Name and address of registered agent. That's for LLCs. It's also for corporations. You got to have a guy or girl or company who's registered with SDAT, who is the mailbox. But it can't be an actual mailbox. It has to be a person or a company. So when and the reason for that, it kind of goes with what we're talking about here. We're talking about a legal fiction. ABC Corp or ABC LLC isn't a person who lives in a house. It's an idea, really. But it's got to have somebody on the ground, so when you sue it, or when you send it a bill, or whatever else, somebody who officially registered with SDAT receives service. You got to give everybody a way to get at that company that otherwise doesn't truly exist. There is a extremely profitable company in Delaware called the Corporation Services Corporation, which is like, makes your head spin when you think about it. What do? They are the registered agent for every company, almost every company that incorporates in Delaware. So what do? They receive all the lawsuits, they receive all the bills, and they've got hundreds of employees doing nothing but acting as the public face, so to speak, of those companies. Corporation Services, it's either Corporation Services Corporation or Corporation Services Company. Actually, I think it's the latter.
You can go online and get those, but if you do business in those different states, like even to go downtown to DC, if you do business there, you have to have a resident agent located in DC.
Yeah, because otherwise you're getting the benefit of the jurisdiction by doing business in it without having to provide a way to people come back after you if you screw it up. So it's cost of doing business, so to speak. The operating agreement. This is like, for an LLC, the operating agreement is like the bylaws in a corporation. How's the thing going to run day-to-day operationally? or a partnership agreement. Method of operations. You can say in the operating agreement that you will default to the provisions of the LLC Act. Again, the Maryland Code says it's a limited liability company act about how these things ought to function. You can default to that, which is easy, but you can also toy with it if you want to do things your own way. And it's got definitions in it. It says what everything else means. Favorable characteristics of an LLC. Easier to operate than corporations. No annual meetings required. You don't need that original organizational meeting that you do with a corporation. Even if it's informal, you still got to have it, which can be a pain. And what I think is the main reason, you don't have a separate layer of management. There's no board of directors as you have in a corporation. You've actually got the members who have the ownership interest are the ones making the decisions. So in a way, because it collapses those functions, in a way, I think it's more suitable to small to mid-sized companies as opposed to large. I mean, GM and Ford are not going to run themselves as limited liability companies. S corporations have limitations. No corporations as shareholders, no more than 75 stockholders in an S corp. Remember that S corps are flow through. They sort of act like a hybrid in that way. They're corporations. They almost act like LLCs because there's no tax liability at the corporate level. It flows through. And that's, I think, partly why you're limited to 75, because that's where the IRS is going to go for its cut. Limited partnerships, don't worry about them. LLCs can have a single member. And that is, yes?
I'm sorry, isn't the S corporation basically a good way for the mom and pop operations? Since that's
Yes.
really the best because it is faster.
Yes.
versus anything else.
Again, drifts into accounting, but
Yeah.
typically yes.
Yeah.
Because why would you want to have to do two
Because it
rounds
is
of
a closed
accounting?
corporation and you're not dealing with the public as far as memberships and stuff like that.
True. The same can also be said for an LLC. I was just about to say that a lot of the tradespeople that we have as clients and that we deal with, it's a guy and his son, or it's a guy by himself, and he simply doesn't want to have to deal with either shareholders or deal with the liability if he was a sole proprietor. So he forms an LLC as his, and he's the sole member. I think a single member LLC is probably your simplest corporate form to protect yourself and then go out into business.
As a single member LLC, could you still have employees?
Sure. And they would be employees of the LLC. They're not yours. And again, it all starts to blur together, especially you got an LLC that's been in operation for 20 years. People forget how they're in business, right? And when people come into me and they say, God, I'm getting sued all over, and I have to say, well, how's your business organized? It's organized as a sole proprietorship, which is to say it's not organized at all, right? Limited liabilities, yeah. The members have the same protections as the owners of a corporation. Now, yeah.
So there's as the way that I read the provisions, there's a distinction between corporations and LLCs that I think is pretty critical,
Right.
if I understand it right. So my question to you is, do I? In a corporation, the shareholders of the corporation, if they have a lien or a judgment filed against them, it can impact, they can actually file on their ownership interest in that corporation. So it can impact the operations of the corporation. Whereas in an LLC, there's a shield, and they cannot get to, because there's not stock per se, it's a membership. So you're protected from any kind of claim or lien in the event that comes to a person who's part of an LLC versus an S corporation.
Well, yes, with regard to the LLC, although I would say with regard to any type of corporation, as a shareholder in the corporation, a lien can attach, and you're talking about exposure, a lien could attach to your interest, meaning the shares that you own, the stock that you own, but that's never going to flow up to as a liability to the corporation itself, other than now they have to deal with the shareholder, former shareholders, creditors as opposed to the shareholder themselves.
Right.
A good explanation, well, it may not be good, you tell me, but an explanation is, in some of our bankruptcy work, people will say, I am a shareholder in a company, and they're usually not talking about shares of a publicly traded company, but my dad started this company, and it's a corporation, and the shareholders are me and my siblings plus my mom and my dad. Do I have to declare that as an asset that would be available in the bankruptcy for seizure by the trustee and or the creditors? And the answer is yes, because that's an asset. It's absolutely an asset. And the trustee in a bankruptcy case is not going to become a shareholder, one of 5 shareholders in mom and pop plumbing, because there's no value in that, but there may be a liquidation value of some type to what that interest is. Typically what the trustee's doing is going to go to the other shareholders and say, buy out this interest for cash. But yeah, the shares that you own in a corporation are an asset that can be liened, can be seized like any other asset, but it's not going to flow up to the company itself. Is that
It's just going to cause some restrictions in
depending on what, well, also,
transfer and whatever other, if the corporation wants to change ownership, or if you want to do something, now you've got a lien and you've got a claim on that. So it's just like I know it's a stretch, but if you're looking at the distinctions between the two, I think it's just another reason, and that's what I wanted to confirm. It's another reason why an LLC is just like almost, too good to be true compared to the rest.
neither of them is perfect. But yes, an LLC provides for the owners the protections of a corporation without a lot of the formalities, I guess is what you'd say. And what you're describing is one of those formalities. No, can't believe what the end. Yeah.
I have a question. We talked about, there's owners, members, managers, and resident agents.
Yeah.
So, can you kind of maybe more clearly define the relationship between, you can have like an owning member or member manager. You have just the manager, it's not an owner.
You're talking within the LLC, right?
Yeah. And then, same with resident agent. And then also with those titles, who can sign, for example, real estate, say for enter into a contract.
Sure.
Or if you have a contract for services, then you have like a project manager that's working for you, or you have a contract with, can you set them up maybe as a manager or a resident agent or something where they can sign?
Yeah. Yes. And I mean, the first thing to remember off the bat is that any member of an LLC is an owner of the LLC. Okay? They're going to have some type of ownership interest. They may or may not have a management interest because you have decided that you want to take me on as a member and you're going to pay me out from the profits of the company, but because of my background or whatever else, you don't want me to participate in the management of the company. And I may not want to participate in the management of the company. That's one way to think of it, right? And there are practical reasons for doing that because you don't want to have to you want to designate a managing member or several managing members because you don't necessarily want to have to get a hold of every member of your LLC to decide on sort of day-to-day operational things. Now, you can have an LLC that says every member is a managing member. That I think gets a little sloppy. But to get a little more to your question, a member of an LLC will be generally an agent of the LLC. If you're making decisions as a member, you're putting the LLC on the hook. You are not putting yourself on the hook because that protection of the corporate form is still there.
And that's defined in the operating agreement, what somebody can approve or not approve.
All of this stuff is flexible and can be spelled out. Right. You may say that you've got a managing member for financial decisions. You may have a separate managing member for operational decisions. You may have a managing member for employment decisions. You can really spell it out the way you want. The registered agent doesn't have to be a member of the LLC. The registered agent can be Joe Blow, who happens to live in the jurisdiction where you are and agrees to accept process on behalf of the company. Kind of get back to why I think the LLC is the favored form, particularly for small to medium-sized businesses. There's a level of flexibility that you typically don't get in a corporation. Yes?
What exactly is an LLLP, and what would be the benefit of that over an LLC?
An LLLP is a limited liability, limited partnership, and it is a specific creature of statute. I'm not that well versed in it because there simply aren't that many of them. But it is a limited partnership, meaning you've got a limited partner, at least one limited partner, at least one general partner, and you've made specific items for which the limited partners are not going to be liable. It's a distinction that, again, I'm not truly conversant on because there just aren't that many of them in Maryland or Delaware. I don't know that I've ever come across one in my practice. So that's not a very good answer, I'm sorry.
That's okay.
And same for I was trying to think of one other, but that's the one I was thinking of. Yes, there's another question over here.
Should realtors be their own limited, LLC?
As opposed to doing business,
As to just, doing business.
there's no reason anyone should do business of any type as a sole proprietor, at all.
I mean, but you've got a broker that's really responsible for it.
Well, then you've got, yeah, I mean, the caveat to that is, whatever your agreement is with your broker, there may be, however the broker is organized, there may be protections that are extended to you as an agent of the broker.
Yes.
Read those documents yourself, because A, you may have all the protections you need already, and B, if you form yourself as a single member LLC, that may actually run afoul of the agreement you have with the broker. Because in essence, you're now no longer in a relationship with your broker. You're saying the company is going to be in a relationship with the broker. I would think you'd at the very least need the consent of the broker to do that.
So as an LLC, a single member LLC, you could still employ subcontractors.
Your LLC will employ subcontractors.
LLC will employ contractors, and then they would be responsible for their own tax burden. You would have to provide them with 1099.
Accounting question. That's really an accounting question. I'll say this.
I'll go with yes on that.
Yeah. Go with they would be responsible, and it would be basis in the form may change as always.
Yeah. I say this also. Whether you're doing as a small business as a corporation or a small business as an LLC, you think, well, the liability is from the trucks and the pianos, but it's also great because I can go in and get the funding I need from a lender to run my business, and if the company defaults, well, they can take the company assets, but it's never going to hurt me. The practical reality is, for any small, and you guys I'm sure know this maybe better than I do, you're never going to have small business lending to a company, whether it's an LLC or corporation, where they don't ask for personal guarantees and probably deeds of trust on your houses of your officers, your members, your stakeholders. And that's just reality. Yeah.
So as an entrepreneur that would provide services and get paid from people by providing that service, from a legal standpoint, best practice would be to become an LLC under some sort of a name.
An LLC or a corporation, and you really have the specifics of the company and what your goals are going to decide that for you. Personally, I think an LLC has has a lot of advantages. That would be my default position, but there may be very good reasons why you don't want to do that. You want to have a board of directors.
No.
Typically, a small business person is not, but there may be reasons, because whatever industry you're in or the personalities involved, that even for a small business, the corporate form may be better. But again, my gut is always LLC unless you explain to me a reason why you'd want a corporation.
And then what are all the steps and facets to becoming an LLC?
Generally, formally, what we're talking about are the documents that we described. I mean, as an initial matter, you want to think about the goals of incorporating. Why are you doing it? First and foremost, because you're crazy not to. Then, and this isn't a pitch, it sounds like one, talk to a lawyer, somebody who can guide you, an accountant who can guide you into which corporate form is going to serve you better. But then you're going to file the articles of incorporation if you're going to be a corporation. You're going to file the articles of organization if you're going to be an LLC. That's the birth certificate for each one that gets filed with SDAT. You're going to have your bylaws if you're a corporation. You're going to have your operating agreement if you're an LLC. Those are going to say how are we going to do business, who has what interests internally, how are we going to make decisions, are there going to be cash call schedules, are there going to be distribution schedules, what's the tax treatment going to be, that type of thing.
And what if you're a single member LLC?
You still want those things.
Okay.
Even though it's all in your head, you want it on paper because it's a separate entity. It has to have its own life, and part of that life is the operating agreement for an LLC that says here's how business will be conducted.
And so, like, let's say you were providing marketing services as an LLC, and someone's business didn't profit from the advice that you gave them, they're not suing you, they're suing the LLC for their losses.
Right. Which is, I mean, that kind of boils down the whole reason we're talking about all this stuff is you want to have that separate person, corporate person. Yes?
How does a DBA fall into as a person? What's the limitations? For example, with real estate contract, a lot of times I have a DBA with one of my entities, and I sign with the DBA, and then half the time I'll get kickbacks. They're like, no, you got to put your whole entity name on there. Then some of them don't care.
DBA?
Doing business as.
Okay.
And a DBA is, don't take this the wrong way, it's sort of meaningless. You could have an LLC, you can have Paul Daugherty LLC, DBA Rock and Roll Management. Doesn't matter, it's still Paul Daugherty LLC. You can have ABC Corp, DBA Rock and Roll Management. It's still a company. You can have Patrick Smith, DBA Rock and Roll Management, and there's no protection in that DBA. It's still you personally.
So if I sign a contract under name Rock and Roll Management or whatever, then that doesn't mean anything.
Nope.
Okay.
Doesn't it basically mean that the LLC is taking on the liability of Rock and Roll Management?
If it's an LLC.
If it's or whatever the entity is.
All it is you're holding yourself out publicly under this name. It really doesn't have much legal effect. So a sole proprietor is a DBA is a sole proprietor. An LLC as a DBA is an LLC. Yes.
Do lenders and insurance companies recognize an LLC? In other words, if you have an LLC, you want to borrow money against as the LLC. As a general matter of practice, do lenders recognize, or are they, Freddie Mac guidelines allow you to borrow money as an LLC?
You can. The lending decision, speaking as a non-banker, but I have bank clients, the lending decision is going to be asset-based, right? They're going to look at basically if we have to collect, what's there.
For the assets of the LLC.
Both, right? Who are they lending to? And in the end, it becomes a bit of a difference without a distinction, because whichever one they lend to, they're going to ask for a guarantee from the other one.
And I'm a lender, and most of the time, then what we require that they have assets and incomes in the LLC sufficient, but a lot of times they still ask for a personal guarantee. So the LLC doesn't really give you any protection against collection.
And you've also got that in my experience, that's right, but also you've got that issue that if the LLC doesn't generate its own income and it doesn't have its own assets, A, nobody's going to lend into it, and B, you may have somebody challenge you and say, that LLC was a sham to begin with because it never had its own life. It never generated its own revenues, never owned title to anything. It was simply there as you were trying to protect it. I'm saying you're doing that. I'm just saying it's got to be legitimate. There have to be legitimate business reasons, and that's part of what a lender's going to look at also.
And following the same thought, as far as insurance goes, say I have an umbrella policy myself that protects me liability, and I own several rental properties. If I have a rental property in an LLC, would that be excluded from the umbrella policy that I have?
You would want, if you wanted to get it under, you'd probably want to have it named as an additional insured, right? It's not going to, just because you have...
Insure it through the LLC
Well,
or jointly, I guess.
the way you said it, you're not going to get coverage for the LLC that owns the property only because you're a member of that LLC. The insurance is issued to you personally. You may be able to negotiate to have the LLC as an additional insured if it's a single member and you're the single member, but you're not going to get it automatically just because you're a member in it.
Yeah, I've heard of people, you have a half a dozen different rental properties. And, some people will form a separate LLC for every property. Others form it for one. But it just seems like you've got to take these other things into consideration, as far as insurance.
Personally, I would want, and I have clients who have that exact scenario, get the LLC individually insured. Don't put it under an umbrella with yourself, unless the umbrella is additional to the separate insurance that the LLC carries. Because you don't want to be, you want the insurance to cover for anybody who falls down the stairs. You don't want that part of your personal policy.
Well, and it goes hand in hand with the practice that I have followed in writing leases. I've had people that want to rent properties as an LLC or a corporation, and I make them be a party to the lease.
And you absolutely should.
I know I can go after the individual. I had no idea conveniently knowing what the LLC was.
Right.
What's the difference between an LLC then and a trust? Because a lot of times you can form a trust to put your properties in a trust, which would be in the idea of, inheritance stuff. But is there an advantage of having a trust like in these situations versus an LLC?
I don't look at a trust as being advantageous for the things we're talking about because you are handing over control of the asset and any income it kicks off and everything else to a trustee. And that trustee may be your brother, but he may be limited in terms of what distributions he can make from the trust. He may be limited to a certain dollar value each year. And you say, well, come on, we put this thing in there to protect it. We established this for a certain reason. We knew what it wanted to do, and now you're telling me you can't kick it out. Well, he may have exposure as the trustee for doing things beyond distributions he's able to make. Much, and I'm not a trust or estate lawyer.
But it's more complicated.
Well, it's much more limited. I mean, the trustee controls the assets within the trust, much less flexible.
Oh, okay.
That's my sense of it.
Makes sense.
Anybody else?
One last.
Yeah.
So as an independent contractor of a business, is there a benefit for establishing your own LLC?
As the contractor? When you say independent contractor, that's an employment.
Independent contractor.
That's a relationship term, right? You're not an employee. You're an independent contractor.
Right.
Again, that flows back to the brokerage question. I think because yes, in a vacuum, rather than you being an individual contracting, it would be better for you as potentially a single member LLC to be the contractor. But that may run afoul of whatever your contract with whoever's on the other end says. Just because it's good for you may not be what they bargained for. They bargained to do business with you, not with your LLC. So it's sort of a qualified response.
Just thought of one. Say you have several members in an LLC and one, maybe decides he's not doing business anymore.
Mm-hmm.
Is there a way you can take a member off the LLC without dissolving the LLC?
You can, and that's the kind of thing you would want to put in your operation or your operational agreement, where you're going to say, for instance, is there a right of first refusal in the other members to basically buy out his interest, which would be my default if I were drafting it, because I don't want. He can't sell his interest on his own anyway, but I want to make sure that I've got first cut at getting it. Okay, if no more.
One more question.
I should have said it, yes.
And I don't know if you can answer this or not, but in the simplest form of an LLC, what is the minimum cost you would estimate that it would cost an individual to set up an LLC?
If we're doing it, you mean to do it with the legal fee?
Well, I know you can mail order
Yeah.
LLCs for a couple $100.
If-
I'm thinking about doing it the right way.
Yeah. I mean, if you're talking about, what the legal fees are going to be if you're hiring us to do it, it's really a time-based thing. I would do it on an hourly basis, and I'm going to spend time with you talking about what those goals are. I'm going to spend time, if there are other members, obviously meeting with them about how you guys want it set up, what you want to do, what you don't want to do, any quirks in that operating agreement, like we're saying, like different management responsibilities. It's going to take 2-3 hours. I mean, I'd say budget probably $1,000 to do it for a simple one. But you're right. You can go find forms. Be my guest, and I'll see you next year.
Or 6 months.
Or 6 months, right?
Mine wouldn't be the simplest set up, so that gives me an idea where it started.
And you know what, we also sometimes, generally for clients we already have, but, I'd be happy to do this. If you've got, we do reviews of people's organizational documents, because, not that I try and scare people in this, and I hopefully I haven't, but people come out and they think about, well, geez, how am I organized? Is it doing all the things I need it to do and not doing the things I don't want it to do? And that's a very low-cost thing. I mean, do that on a flat fee for a couple $100 to look at your stuff and say, you got a couple red flags in here, or, hey, this thing's real good. So, be the better route for you. All right, well, thanks for coming. And again, my car, I don't know, somebody look at their phone and see if my card's in there. Is it? Okay. That's got the phone number, also has my email address. Feel free to use it and get in touch. I'm happy to speak with you and not send you a bill. But also, please do fill out the questionnaire, because we really do value it. So, thanks again.